Well, good afternoon. Thank you, everybody. Welcome back. Zach, I think you've got, or Commissioner Council.
So in order to return to open session, I need you to attest that the only matters discussed in the closed session were those that were listed in the motion. Can you so attest?
Yes, I can.
All right, thank you.
So returning to regular order and regular session, my understanding is both sides have closed your cases in chief, but you are now turning to rebuttal, starting with the applicant. Is that correct? Please proceed.
And we'd call Stacy Fry. Stacy, you there?
I'm here.
She's muted for some.
Can you hear me?
Stacy? Oh, there she
Hello?
is.
Can you hear me?
Yes.
Okay.
Okay, Ms. Fry, I'm just going to ask you a question about this exhibit R1. What, as a geologist, what did you do on this exhibit?
So this exhibit shows a map of the pH of the Third Bone Spring sand and the Wolfcamp XY sand across the development area, where high pH is in red and low pH is in blue. The map also shows the third sand and upper Wolfcamp wells filtered down by a set of criteria determined by Mr. Weinkopf, our reservoir engineer. I've cross-plotted pH versus total fluid EUR per foot on the right side of the slide, which shows a correlation of 0.81, which means that these variables have a high positive linear relationship. I've also broken out the correlation by a few different segments of the Wolfbone Reservoir. The upper third sand on the left, the lower or basal third sand, which is Coterra's Landing, the Wolfcamp XY, and the Wolfcamp A shale. The correlations are the highest in the upper and lower third sand, and only a 0.37 in the Wolfcamp XY and a 0.08 in the Wolfcamp A shale, which means that the Wolfcamp A shale has a negligible relationship with production, and the Third Bone Spring sand is the driver of production in the area.
Do you have any other geological testimony with respect to this exhibit?
No, I do not.
Mr. Chair, that's all the questions I have for Ms. Fry. I tend to her for cross.
Cross X.
Good afternoon, Ms. Fry. Looking at your rebuttal exhibit R1, my understanding is that this relates to correlations, not to an R-squared analysis, correct?
Correct.
And so if we were to convert this to an R-squared analysis, we would simply square the correlation coefficient, correct?
Correct.
So in all the previous discussions about relationship between fluids, either total fluids or oil and phi height, we've been talking about it in terms of R-squared, correct?
Correct.
So in order to make this apples to apples, we would simply square your correlation coefficient to get a 0.64 R-square relationship, correct?
Let me calculate that real quick. It would be a 0.66.
Okay, so we're still looking at essentially almost over 40% of the data identified in your correlation as being explainable by mere randomness, correct?
Variance, yes, but I still believe that this is a strong positive linear relationship.
Well, is a correlation a relationship, or is it? I mean, I know the idea about something's correlated, like, oh, every time I wake up, the sun's up. Therefore, when I wake up, I cause the sun to rise. Right? It's a little different than actually a direct causal relationship, correct?
Yes,
And correlation doesn't say that there's a causal relationship. It just is related to, correct?
correct.
And then, so we're looking at a 0.66 R square relationship based on your, I guess that would be for the third sand and Wolfcamp XY fee height analysis, correct?
Third sand and Wolfcamp XY, yes.
Okay, and so based on what I understand here, you say that you've filtered some data points in order to achieve that correlation or that R square now that we've calculated it. And the filters that you've applied are underneath the map in the bottom left, correct?
I did not apply those. My reservoir engineer did.
Okay. So you didn't do this, but there are, I'm going to count 1, 2, 3, 4 different filters applied, right? One being the propant used, correct?
Yes,
One being the yield, correct?
correct.
Another being the water cut. Is that correct?
Yes.
And then the fourth one being the density of the wells, correct?
Correct.
And so there are 4 filters applied, which eliminated a number of other data points, correct?
Correct.
And you didn't yourself do this, but somebody at the engineering team did this for you, correct?
Yes.
So was it your decision to apply these filters or theirs?
It was theirs.
So I can't ask you the rationale behind those choices, can I?
I would refer to Mr. Weinkoff.
Okay. But this is your rebuttal testimony, right? Your rebuttal exhibit, correct?
It's kind of a combination.
Okay. So as to the rationale, then I'd be better served directing my questions on that point to him, correct?
Yes.
Okay. No further questions.
Nothing on redirect. And that's the end of the testimony for Ms. Fry. Now I'll call Mr. Weinkoff. Oh, I apologize.
Commissioner Thompson, any questions?
No questions. Thank you.
Council? All right. Thank you, Ms. Fry. You may proceed to your next witness.
Recall to the stand, Mr. Weinkoff. Mr. Weinkoff, can you elaborate on Exhibit R1 from a reservoir engineering standpoint? And hit the points that Mr. Rankin was talking about, the filters.
Yes, absolutely. So in reservoir engineering, we try to understand what well results are genuinely analogous. This is a common practice in reservoir engineering. And so in order to do that, we need to properly characterize the wells that would be analogous. And so when we look at each of these filters or the criteria that we've submitted, we're trying to narrow the scopes that would be roughly the range of characteristics for each component that we might observe at Mighty Pheasant Loosey Goosey. And so when we look at, for example, yield, there are differences in recovery depending on if the fluid type is much more mature, meaning it's gassier than what it is. So we are applying these again to try to characterize the offsets similar to what Mighty Pheasant Loosey Goosey could be.
And is there any other reservoir engineering testimony on this slide for you?
Yes, what I would comment on the correlation versus the R squared, an R squared above a 0.6, and I think Coterra's geologist had stated 0.66, the exact number, would be considered a strong R squared or strong linear regression for the data. So even though there's the point that the number is a correlation, we would still look at this as a very strong correlation between total porosity height and total fluid height.
Is there anything else on this slide you want to comment on?
There's not.
Let's go to R2. And can you tell the commissioners what this slide is depicting?
Yes, so this is taking the next step when converting total fluid to predicting oil recoveries. And so what we're effectively doing is looking at a relationship between total fluid on the y-axis and oil EUR on the x-axis. And the data points are concentrated around the mighty pheasant loosey goosey just to illustrate the well results near there. And specifically there, we have called out the developments that are called out on the map. And so what we're showing here is that when we narrow the focus even more so, we see that there's a strong correlation with the offsets between total fluid and oil EUR. So this is evidence that contradicts what Permian Resources technical experts have said, that there is not a strong correlation, or there is no correlation. So we believe that total fluid can be representative of the oil recoveries. It just requires 2 steps in the process to do the conversion from porosity height to total fluid to oil EUR.
And this is a rebuttal to F-17.
That's correct. There was also verbal testimony given talking about how there wasn't a strong relationship with porosity height and oil.
Is there anything else on this slide that you'd like to discuss?
There is not.
Moving to R3, can you discuss this slide?
Yes, R3 is important because it walks through an example of looking at revenue versus looking at an economic metric that accounts for revenue and the total costs that the wells observe. And Permian's pre-hearing statement, they reference a couple of times about revenue being a reason why all stakeholders would benefit from Permian Resources plan. But revenue doesn't include operating expenditures or capital expenditures or production taxes that the working interest holders would observe. So if you're trying to understand what the working interest holder will ultimately receive monetarily, you need to look at a number like a BFIT cash flow, which again, that's before income tax. So that accounts for revenue and all the costs. The table on the bottom right walks through an example of that using an example Coterra had put together showing Coterra's plan versus Permian Resources plan, and just simply shows the values of the revenue versus what the unit's BFIT PV10 would be. And you can see that when you compare the revenues, you might come to an answer that says PR's plan would generate more revenue. However, when we look at the costs fully burdened onto the working interest owners, we see that the value the working interest owners will receive actually states, at least in this example that we're showing, that Coterra's plan is better. So you need to take into account all the costs to be able to determine what is actually optimal for working interest holders.
Is there anything else on the slide that you want to talk about?
There is not.
And let's go to slide R4, exhibit R4.
Yes, we're submitting a rebuttal exhibit R4 because there is actually a couple slides that do not represent Coterra's full development plan.
And they would be exhibits F1 and F2.
That's correct. They are missing the upper second bone spring wells that Coterra has on their wine rack in their direct testimony. And so because these wells are left off of the PR's exhibit, they're also left off the table where they try to illustrate what the economics could be for Coterra's plan. And so I do want to state that earlier in this testimony, we've talked about Coterra's plan and how it plans to develop. And it's important to look at the timing because timing impacts the BFIT PV10. If you recall from my testimony in PR's reservoir engineering, we're trying to model cash flow over time. And so I do want to comment about the timing. So on this exhibit, what we're illustrating on the table specifically is PR's plan. Now this table has PR's updated costs that they provided for this hearing, and we ran it against what Coterra believes that plan will ultimately recover. And as far as timing goes, we've made a timing assumption that PR would develop all those wells at the end of Q1 of 2026 or the first quarter of 2026. Coterra's plan, full development plan, highlights that we're going to drill. We would drill the first, all the second Bone Spring, and the third Bone Spring wells. And so, looking at the timing of Coterra's development, we have the third Bone Springs being developed before the end of the year. Coterra already has permits for one of the developments, and we can get the permits for the other development within the next couple of months. And then as far as the remaining first and second Bone Spring developments, we have timed those out a year from today for the second Bone and a year and a half for the first Bone Spring development. And that would be our timed plan going forward. So we're giving Permian Resources the benefit that their full development plan is being drilled in Q1, but Coterra's is being drilled over a series of time. And so when we look at the table, we're illustrating the economics of both plans on a flat 65 price file. And so you can see Coterra's well count is 30, PR's is 48. We've listed the oil recoveries. We've listed the capex to develop both units, which this is an important note because Coterra's plan only requires about $280 million, where Permian Resources plan per their provided 2025 costs would cost $411 million. We would estimate that the BFIT cash flows based on Coterra's models, but PR's capex provided would deliver PR roughly $409 million compared to Coterra's $415 million. Now for Coterra, those millions of dollars matter. However, if someone were to say, well, that's close enough, right? What are we doing here? I would direct your attention to the bottom two rows of the table, which are there to really illustrate the capital efficiency of both plans. So effectively, I spent $1 of capex. What did I actually get in return? So if we look at PR's plan, for every $1 of capex that they spend, Coterra would predict that they would roughly get $1 in return. Compared to Coterra's plan, if Coterra spent $1, we would expect just under $1.50 in return. And so that illustrates that Coterra's capital is working more efficiently, and that savings that Coterra is providing for working interest holders can be utilized to invest in other projects in the area and thus provide them more money. This is only focusing on this project, but the savings, again, that Coterra is providing the working interest holders actually would allow the working interest holders to make additional money not captured in this. The last row illustrates a similar column that we've showed in our direct testimony, which is how much oil did I get per $1,000 of capex spent. And again, this is reinforcing the capital efficiencies and oil recovery space of Coterra's plan. Because Coterra has well spacings that are more reasonable, we are able to recover higher oil amounts per $1,000 of capital spent. Again, these economics assumptions assume a flat 65 oil price, but include Coterra's 2025 costs and PR's 2025 costs.
Anything else on this slide you'd like to discuss?
The only other thing I would add, and this goes to the timing element, was Coterra's landman testified that Coterra could only drill 10 wells as of today. And she's basing that on her land, her specialty as a landman, and that would be the permits Coterra would have to be able to drill today. But the reality of it is we'd be in the process of getting the second Bone and first Bone Springs permits as time allowed. As far as operationally, Coterra could drill all of these wells today if it wanted to, but we have to go through the proper permitting processes with the governing bodies.
Let's go to Exhibit R5. Can you talk about this exhibit?
I can. So on PR's Exhibit F7, they state that modern developments are outperforming legacy result offsetting Permian Resources and the Harkey Sand. And so they state that there's economic potential. Coterra finds issue with this because the wells that they're referencing to make this statement are not located near Mighty Pheasant Loosey-Goosey units. The plot or the chart on the bottom right, the cross section of the logs, illustrates the Harkey Sand, and it effectively is highlighting the net sand that we believe the Harkey Sand provides. And so what we walk through is on the western side, on the west side or the left side of the cross section, that's starting from the southernmost developments. That's where PR showed the best well results. So we can see the Harkey Sand is very thick there. As you move north and towards Mighty Pheasant, you can see that sand body thins out. So the Harkey specific interval is getting worse. They reference the Sandra-Jean as being a positive well result. If we look at the Harkey Sand, we're estimating roughly 142 feet, but yet at Loosey-Goosey, we would estimate roughly 22 feet. That is significant reservoir degradation. So the potential recovery of the Loosey-Goosey unit has the potential to be compromised. And it's my and my geologist's opinion that the well results will be much worse than the southern area that PR is referencing for promising results. There was a statement made by Permian Resources engineer that Coterra thinks the Harkey's economic. That's not true. We do not believe that. They made that assertion based on the table on the top right-hand side of the rebuttal exhibit. And they're claiming that we're showing a PVI 10 of 0. That column is titled added unit BFIT PVI 10. We're stating that these wells add 0. The actual BFIT PV 10 of these wells is negative. And so we're just illustrating that there's no added value on that column. So it's very important to see the added label on that column. So effectively, for both units, $73 million is spent, but yet $0 is gained on a BFIT PV10 basis, assuming a 65 oil price file. The plot on the bottom left illustrates the Coterra's forecast to model these wells. And so if we look at the Sandrigine, which is referenced in red as a modern development, we can see, based on my comments earlier, that the sand body was thicker. The Hammond unit, which is offsetting Mighty Pheasant Loosey Goosey, was claimed to be vintage. And although it doesn't have the 2,500 or the 2,200 pounds completion that some might test, it's still a 1,500 pound per foot proppant job. And so Coterra is modeling upside from those well results, and yet we're still not seeing any economics. So we do not believe the Harkey landings add any value, and that is very important when looking at the full development plan.
And anything else on R5?
No.
Let's go to R6.
So Permian Resources also claimed in Exhibit F10 that the west half of the Batman Third Bone Spring wells were not degraded by the inclusion of the XY wells, stating that the XY wells were not impactful. However, they did not show you the Robin development compared to those in isolation like they did the west half of the Batman. So on the top right-hand side, you can see a wine rack where we've got the Batman on the left and the Robin on right. And boxed in blue and red are the Third Bone Spring wells, modeling the east half of the Batman as one average and modeling the Robin's Third Bone Spring and together on average. And so what we're trying to show here is another example to contradict what PR has shown, where the XY sands were not impacted by the Third Bone Spring wells of Robin were impacted by the XY sand. The plot on the bottom left illustrates the productivity difference and the ultimate recovery difference between these two groups of wells. So the Batman east half, which does not have any XY sand wells drilled beneath it, is in blue. And the Robin Third Bone Spring wells, which are in red, you can see that the ultimate recovery is predicted to be lower. Now, PR also asserts that the Robin potentially may not be a valid well point because there's offsetting depletion. Coterra does not agree with this. If we look at the bottom right plot, we can see Coterra's oil recovery versus well spacing, and we've flagged where the Robin is on that plot. So oil recovery factor, again, is the well's EUR divided by the oil in place. If a well observes depletion, then those are reserves removed out of the system, and thus the EUR that well would potentially have would be less. So we would expect the oil recovery factors to be lower if there were depletion signatures. As can be clearly observed on our oil recovery factor plot, the Robin is in line with surrounding developments and the trend that Coterra is modeling. And so we would look at this and say, this is hard evidence that states that the Robin does not observe depletion and should be considered an analog for comparison. And that's very important.
And anything else on this exhibit?
No.
Let's go to R7. Please explain this exhibit.
So on F12, PR incorrectly asserts that Third Bone Spring working interest owners would benefit from their development plan. We've heard testimony from PR's geologists that they expect that the XY Wolfcamp wells will drain into the Third Bone Spring. Now, while he also asserts that the Third Bone Spring wells will drain into the XY, there's a question of what percentage of drainage happens between those wells. And that has already been heard, and there's already been a ruling provided in 2024 where the Third Bone Spring and Upper Wolfcamps together combined are the wolf bone and are a common source that is located predominantly, that supply is predominantly located within the Third Bone Spring sand. So if Permian Resources geologists is admitting that, in combination with the ruling that was issued last year, this would state that effectively the Third Bone Spring working interest owners are losing reserves to the Wolfcamp owners because that common source of supply is predominantly located in the Third Bone Spring. To illustrate the potential magnitude of not having an allocation formula, I direct your attention to the bottom of the slide. The table we're showing of Coterra's proposal and PR plan was already shown early, but it's rolled up between both units. So Coterra's proposed plans of 8 wells is for the Mighty Pheasant Loosey Goosey, and PR's proposed development is for 16 wells, 8 wells for Joker, 8 wells for Bane. And next to it, we've got the associated CapEx and unit BFIT that those plans would generate based on Coterra's cost. This exhibit is based on Coterra's cost and a flat 65 oil price. The box highlights PR's plan and the impact to Third Bone Spring working interest holders and Wolfcamp working interest holders. The left side is the Third Bone Spring working interest holder. So this example looks at it on a gross basis. So a Third Bone Spring working interest owner has 100% in that unit, and we're assuming a net revenue interest of 77.5. The table below shows the difference between having an allocation formula or not having an allocation formula. And so the 70-30 allocation formula would provide Third Bone Spring working interest holders approximately $161 million of BFIT PV10. The total oil EUR on the 70-30 allocation would provide Third Bone Spring working interest holders approximately 11.5 million. If there is no allocation formula, or effectively, if we simply let surface acres dictate this, then the Third Bone Spring working interest holders would only receive half of PR's plan, which would be $115 million of BFIT PV10. So to state this plainly, Third Bone Spring working interest holders comparing these two approaches would lose $46 million. And in total oil space, they would lose 3.3 million barrels. That's significant. If we compare that to the Wolfcamp working interest holders, we're observing 100% working interest holder in the Wolfcamp and the same net revenue interest. And the table below again compares the 70-30 to the no allocation formula. And what we're illustrating here is the reserves that are being increased and the economics that the Wolfcamp owners are seeing an increase in is directly coming from the Third Bone Spring working interest holders. So despite a ruling stating that the majority of the supply is coming from the Third Bone Spring and that the Wolfcamp is one common source, if we don't have an allocation formula, Third Bone Spring working interest holders will lose money and oil reserves. And that's very important.
Mr. Weinkoff, do you recall the question the general counsel asked of PR's reservoir engineer about waste and what our case is for waste, economic waste? I'm not sure if he's going to ask that question of you, so I'm going to ask it.
I recall some of that testimony, yes. With respect to what we're seeing here, we're looking at economic waste in several ways. What the wells will ultimately recover for what is spent. So we can think of the Harkey sand, where we're not going to observe additional monies. And we can look at economic waste and the result of potentially robbing a working interest holder of their not having their proportioned, equitable proportion of production and monetary compensation.
Is there anything else on R7?
There's not.
That's all the questions I have for this witness on direct.
Any cross?
Yes. Let me get my exhibits for a moment. Okay, starting back at rebuttal exhibit R1. Were you the engineer who applied the filters in this case for as the part of the analysis?
Yes,
And the filter you applied, at least as the well spacing, was that you included wells with 2 to 6 wells per section,
yes,
and you excluded all others?
that's correct.
Okay. And so in this instance, you don't have any wells at the spacing that Permian is proposing, do you?
No, I do not.
Okay.
There are no 8 wells per section Bone Spring developments in this area, as PR's technical staff has testified to,
Are there not
that are
at that,
producing.
are there not at that density?
When you say at that density, what are you referring to?
At the density, at the full section density that Permian is proposing?
You're asking me to clarify the question. You're asking is there a wolf bone or wolf bone equivalent development that has 8 wells producing in it today?
That's not what I was asking you, but I'll reframe my question. In this instance here, you've not included any wells that at 8 well per section density, or that there are no wells in your database because there are.
No, in this area, we have not, what we have filtered down to does not include any 8 well per section developments.
Thank you. Slide R2. My understanding is, like, when we're talking about fee height or porosity, that basically when you got porosity, either you got water or oil that fills that space, correct?
No, that's not correct.
What
It's
else
not
would be
water
filling?
or oil. It's water and oil.
Okay, so let me rephrase. It's either water and or oil, correct? Water.
If you wanted to generalize that statement, I have not observed a reservoir that did not have water in the pore space.
Okay, so my point is that we're looking at, it's a binary system, right? It's water and oil, that's it, right? Those are the two material, physical things that could be filling the pore space, right?
For the maturity of this reservoir, yes, and reservoirs that are more mature, gas can sometimes be out of solution and also be in the pore space. But in this particular area and what we're talking about, oil and water, that is correct.
So you're telling me that whenever you find water or oil, whenever you find oil, you're going to find water, right?
Can you rephrase that
Yeah,
question?
wherever you find oil, you're going to find water, right?
Yes, to some extent.
So in other words, this relationship is just telling you what we already know, right? Is that whenever you find oil or water, there's going to be the other, correct?
No, that's not necessarily the correct conclusion.
Well, you just told me that it's always oil and water.
Yes, but you didn't take into account the percentage of each of those and the characteristics of the reservoir that dictate that.
Does this tell me what the percentages are?
So what we're looking at is units around the Mighty Pheasant Loosey Goosey, where we believe the water cut or the water percentage in the reservoir would be similar to that of the Mighty Pheasant Loosey Goosey. So we're not explicitly saying that because we're using the surrounding analogs that would be roughly analogous.
And again, you're on your x-axis, you're using EUR, correct?
That's correct.
And again, that incorporates your assessments, interpretations, and experience as an engineer.
Yes,
And they're not absolute values, right?
they're based on my estimates. That's correct.
And going back to slide 1, or our exhibit R1, again, when we made the correction or modified the correlation to an R square, and the result is 0.66, do you agree with that? Converting that to R square?
I didn't do the exact conversion, so I would trust the math that the geologist had done, and that I believe you stated as well in your question.
Right. So basically that, that tells me that we're looking at 36% or 36% of the data being explained by randomness.
It's not explained by randomness necessarily. It's explained by other characteristics that aren't being represented on this plot. So a linear regression is a trend line through a independent and dependent variable to create a relationship, and that value determines, how much of that independent variable would impact the dependent variable. So as I stated earlier in my testimony, anything above a 0.55 would be very good for the oil and gas industry.
For what purpose?
We're trying to determine how well a variable correlates or predicts is the way to say that when we're considering R squared, how well it predicts another variable.
How about allocating tens of millions of dollars?
What's the question? Can you state a whole question, please?
Well, I'm just following up on what you said was that it performs very well for the oil and gas industry. And an R squared 0.66 is a very good relationship for the oil and gas industry. I'm asking you, how about for allocating tens of millions of dollars?
So far of what we've looked at, this is one of the stronger correlations to do that. I've not seen an alternative method that has proved a better correlation.
Okay. So in your opinion, as you sit here today, do you stand behind, this is the best correlation you come up with, that relationship where 0.34 accounts for essentially randomness of the data is sufficient to allocate tens of millions of dollars?
Objection. I think he's mischaracterized his testimony.
Would you like to rephrase?
Yeah. So you're telling me what is the inverse of the 0.66 R square? What does the R6 square represent to you?
You said two differing pieces in there. You said, what does the inverse mean? And then you stated, what does the 0.6 mean?
So tell me, what does the 0.66 mean in terms of a relationship between the factors, the variables?
Yeah. So if you had to state the range of an R squared between 0 and 1, that would be 0 being this variable is not that predictive and predicting the dependent variable. So in this case, the dependent variable is the total fluid EUR, and a 1 would be it predicts it very well. And so when I see an R squared of 0.61, I'm seeing that this variable is characterizing most of the is predicting most of the amount of what total fluid is for a given total porosity height.
And as you're sitting here today, you're telling me that that's sufficient to allocate tens of millions of dollars to different owners across the different depths.
I believe I've answered that already in stating this is the one of the best ways I've seen. I haven't seen a way that's provided a tighter correlation.
Would you want your tens of millions of dollars allocated with that ratio?
In the oil and gas industry, our job is to characterize a reservoir beneath the ground, and we utilize producing well results. We utilize log correlations to make the best prediction that we can. And so the data is not always clean. And in fact, in this part of the reservoir, and I would expect Permian Resources to say something similar, we do the best job we can with the data that we have. So based on the data that we have today that's available to us, I do believe so.
So you're comfortable with you'd be okay with it allocating your money?
I believe I've already answered that question.
Well, I wasn't clear from your answer actually, so I wanted to make sure.
Yes, using the best data available that I have, I would feel comfortable using this.
Okay. Let's move on to your next. Let me just see if I covered what I wanted to here. On R3, did you hear Permian Resources engineer witness testify that in his economic analysis, he included all cash flows and every line item that you included here was part of his economic analysis?
I did, but this slide refers to the pre-hearing statement.
Okay. And as to Exhibit R4, rebuttal at R4, those upper second Bone Spring wells were not included in Coterra's well proposals, were they?
Can you be more clear? What well proposals are you referring to?
Sure. As part of Coterra's exhibit packet and the wells that Coterra proposed for its development plan, these upper Bone Spring wells were not included in that well proposal, were they?
When you say well proposal, do you mean in 2023 when the wells were initially proposed?
Yeah.
They were not.
Right. And they haven't been proposed at any time since then to the working interest owners in these units, have they?
No, we have not.
Nor are they included in the 5-year development plan that was submitted to the commission as part of Coterra's exhibit packet.
I'd have to look at it to refresh my memory.
Okay. Well, I guess the record speaks for itself. Would you agree with me?
If the record states that, then yes, I accept the record.
Looking at Exhibit R4 on rebuttal here, as part of the case in chief, Coterra has alleged or claimed that all of Permian's development constitutes economic waste. Agree?
We state that the development plan creates economic waste.
And initially, as part of the case, Coterra has always claimed that the drilling of these Harkey wells would constitute economic waste. Agree?
I'd have to refresh myself on previous testimony, but my testimony today is that it creates economic waste because we do not think they will add value.
Okay. And in none of Coterra's direct testimony in its direct case did any of Coterra's witnesses address the Harkey wells. Is that true?
We did not address it because we didn't think it was worth addressing something that adds zero value.
Okay, so it was not part of your case in chief, correct?
When you say case in chief, we don't.
I'm listening to court. What?
When you say case in chief, we don't list the wells in our development plan. So therefore, we are stating that we don't think the Harkey will add value. So it is in our case in chief.
Let me just say this more directly. In your direct case in this hearing proceeding before the commission, none of Coterra's witnesses addressed the Harkey wells as demonstrating economic waste, correct?
We did not comment on the Harkey wells.
Thank you. Okay, going back to R6, you testified that, and this is a change in the testimony from Coterra, that actually Coterra could actually drill more than 10 wells in a year. Is that correct?
So as I stated in my testimony just a moment ago, the testimony was given by a landman, and she gave that perspective from her expertise, which would be around permits that Coterra has. Coterra is in the process of or has part of the 10 wells. So from her perspective, from a landman's expertise, that's all we can drill today because you can't drill a well without a permit. However, she was not making any assertion, as I understood it from her expert testimony in her area of expertise, around whether Coterra could or could not operationally drill more wells today.
But I guess her testimony would whatever it says is in the record and it stands for itself, correct?
It's of record.
Okay. But you're telling me, as you sit here today, that Coterra does have the capability, setting aside whether it has the permits or not, to drill more than 10 wells. Agree?
That's correct. Okay. Operationally, we do.
But even if you could drill more than 10 wells and drill all 30 wells at one time, you couldn't because of the infill well rule, correct?
I'll have to defer you to legal counsel on the determination of 2023 guidelines when these wells were proposed versus what the guidelines are today.
Okay. So, yeah, I mean, the regulations are what they are, correct?
Yeah, the regulations are what they are in 2023 as they are what they are today.
Correct. And if you don't have an initial well drilled, then you wouldn't be able to drill infill wells.
I believe I told you that it's not in my area of expertise.
Very good. In Exhibit R5, where you've got this column here, unit CAPEX, are these based off of Coterra's costs?
As stated on the footnote right below the table, they are based on Coterra's CapEx.
Okay, and so these are not using Permian Resources 2025 AFE costs, correct?
They are not.
Okay. spend a little time on this exhibit here because I want to make sure it's clear.
Can you zoom out a little bit? I can't see the full exhibit on my screen, please.
Well, when I'll put it on full screen mode and then we can deal with it that way.
I appreciate that.
So as I understand, the premise of this slide is that there was an order issued by the division that suggests that there is most of the reservoir is in the third Bone Spring, right?
I would object to the characterization of it being a suggestion.
Well, we'll get to it. I'm asking him to tell me if I'm right or wrong.
Can you restate your question,
Sure.
please?
The premise of this slide is that there's an order from the division that identifies or appears to state that there's the majority of the reservoir comes from the third Bone Spring. Is that right?
I would object as to it, the use of the word appears to indicate. It either indicates it or it doesn't.
I think you can, your question seems to function just well without the word appears, right?
That's fine. We can extract the word appear. That's fine. I can pull up the language of the order if that would be helpful. So let me do that. Okay, let me go ahead and do that. One moment. One second. I thought I had it. Okay, have I highlighted the language here that is the premise for the analysis in that slide we were just discussing?
That is one piece of that, correct?
Okay, so when I go back to this slide, my understanding then is that based on that paragraph that I just showed from the order, you've indicated here that you've shifted the production from based on Permian's plan and data, and you shifted 70% of that production up to the third Bone Spring owners, correct?
I'm illustrating what the allocation formula, how that looks relative to no allocation formula between third Bone Spring working interest holders and Wolfcamp working interest owners.
Okay, so my question is, in this analysis, you've taken 70% of the production from the Wolfcamp well that Permian is proposing, and you put it up into the third Bone Spring, correct?
That's our allocation formula that we've represented.
Yeah, the answer is yes or no. You took 70% of the production from Permian's Wolfcamp well and you put it into the third Bone Spring, correct?
That's correct.
Okay, and you did that on the premise of that statement in this order 23089, paragraph 6, correct?
Yes, you're referring to where the order explicitly says the common source of supply located predominantly in the third Bone Spring.
That's correct.
Yes, that's correct.
Okay. One moment. I know. Yeah. So in that same order, okay, that we're just looking at 23089, at the conclusion of it, the division orders and states that the record is left open in order to allow the parties to propose a wolf-bone pool. Do you recall that?
I don't recall that full piece of that portion of it.
Do you disagree that I'm showing you that language here in that order right now?
You're showing me one sentence that says that, so I agree that you're showing me that statement.
Okay. So the division, after making those findings, left the record open for such a proposal and will prompt a reopening of the hearing record on both applications. Did I read that correctly?
Yes, I believe so.
Okay, and then it goes on to say that OCD retains jurisdiction of this matter for entry of such orders as may be deemed necessary. Did I read that correctly?
You did.
Okay, so did both parties actually reopen the record by filing a proposal for a wolf-bone pool?
That's out of my expertise.
Did both parties, you're not aware whether they did or didn't?
I wasn't over this area. I'd have to refer back to.
Okay, so if I can represent to you that both parties did. In fact, your counsel even discussed it during the hearing today.
Okay.
So both parties did file an application for a wolf bone pool, correct?
Okay.
And as a result, wasn't the record reopened based on the language of this order?
You're taking one piece of the order, but there's another piece that provides an actual statement,
Okay,
and that's the premise of Coterra's allocation formula.
very well. I understand that. We discussed that. So now that we have the record open, the division issued a subsequent order, R23089A, correct?
I will take you at your word. You're showing me it here right now.
Okay. And in that order, did they make a similar finding? Did they reconfirm the finding that actually there is finding that there's a predominant portion of the reservoir in the third Bone Spring?
I would
I
have.
would object to the question because I think as a legal matter, well, he's calling for some legal testimony from the witness on the scope of reopening the record. I think that, as Mr. Rankins is apt to say, the record stands for itself. It was reopened in order to create the wolf bone pool. And the finding that it's predominantly from the third Bone Springs was never contested by either party after that. So although the record was open as a legal matter, it was open to do the wolf bone applications. And Permian didn't appeal that part of the record that made the finding that he referred to earlier about the predominant source of hydrocarbons.
So the basis of the objection, just
Basis of the objection is, well, first of all, he's asking for Mr. Weinkoff, a reservoir engineer, to analyze an order in the scope of the order and what's allowed under the order. He doesn't have the expertise to say that. And as a matter of law, Mr. Rankin's proposition that the record was reopened to challenge that is wrong. And as a matter of fact, no one ever did challenge that. And that was a final order that was never.
May I have a moment to respond? I'll take a second. I think.
yeah, but I might
Sure.
help you in
Yeah.
because I'm also so the record is, I mean, the administrative record, we're going to take notice of what it is, right? All of these orders that the division has already, and I don't think anybody's challenging their authenticity. So if you can help me understand what you're hoping that this witness can
Sure.
add to these orders,
Sure.
that would help me.
So just for context, what's happening here is that Coterra has taken the position that the division has issued a finding about where the predominant reservoir is located. What I'm not asking the witness to make any legal conclusions. I'm asking factual questions about what the order says or doesn't say, and then the procedure that followed. I understand that there are potential legal issues around those, but I'm not asking him to draw any legal conclusions or make any legal statements. I'm just asking, because he testified in his testimony several times, what the order says. And I'm asking him to identify other aspects of what the order says. Here, the point is that it was an interlocutory order, it wasn't a final order. The record was reopened. And from that point forward, actually, the entire time, Permian has contested the allegation or claim that the wolf bone, that the third Bone Spring is the predominant source of the reservoir. And as was demonstrated through this hearing and at the conclusion of the division, is that no, it isn't. In fact, they modified their finding to just simply say that Cimerex's testimony was that's how that reservoir is allocated. And my point about this is that his premise for his rebuttal exhibit is based on a misunderstanding of what the procedural aspects of the record are. And I can leave it there and we can deal with it in closing, but that's the gist of it, is that the contention of what the record provides is not does not square with the witness's testimony.
I think that is something that you can deal with in
Yeah.
closing. But if you want to narrow your question or somehow reframe it to, if there is something specific to this, that you want this witness to testify as to his understanding or impression or otherwise how he, if you could narrow the scope of that question so that it's not merely, what is in the order, because that
No, I understand.
the
I
record
believe-
will speak for itself.
I believe I've accomplished my goal here, and he's indicated that he is, the premise of the rebuttal is that it's based on this provision in the order. And I think I've established that for the record, and that's all I wanted to do. So thank you.
In that case, do you have, move on to the next question then?
Yeah. And that actually may have been. Let me just confer with my client for one moment and make sure I covered everything that I've been asked to cover.
No problem.
No further questions.
In that case, Commissioner Thompson,
No questions. Thank you.
Commission Counsel,
Yes, whoever's controlling the screen, can you go to Permian C11? All right, does that have a 165 at the bottom? Okay. So earlier, in response to some questions from council, I believe you said there's two big wastes. One, too many wells, and that the Bone Spring owners' interests are being wasted. Correct me if I didn't say that right. What did you say?
Yes. So the second piece specifically is what you're asking about.
Well, first I need to confirm that we're on the same page.
Okay. I did make a statement about two pieces, one being the amount of wells drilled and one being the impact at Third Bone Spring interest holders.
Okay. So help me out here as we're at the closing hours and I'm getting ready to write some findings as we go forward. So think of yourself as dictating, okay? The way I read C11 at the very bottom, it says entities with greater interest in the Bone Spring. Can you see that on your screen?
At bottom left there.
Yes.
Okay. I do see that.
Okay, so the way I interpret that is that these are the people that are being harmed. Is that how you interpret that?
Yeah, it would be people who have disproportionately higher ownership in the
So
Third Bone than the Wolf Camp. That's correct.
So when your counsel and you talked about the people, the waste to the Bone Spring owners, this is our universe of people that are being harmed.
Yes, in this unit.
Okay, in the Joker unit. So the way I understand this is that one of them is Magnum Hunter, okay? The next one is Highland, then Avalon, PR, and Prime Rock. Did I read that correctly?
You're referring to the far left column of their table.
Entities with a greater interest in the Bone Spring, Magnum Hunter, Highland, Avalon, PR, and Prime.
Down there. Okay. Yes, I see that.
Okay. And then looking at the status, it looks like Highland is on Permian side, Avalon is on Permian side, and Prime Rock is neutral. Did I read the status column correctly?
Let's see. This isn't my exhibit, so I have to read it as you ask me this question. Yes, I believe that is correct.
So there's nothing wrong with Magnum Hunter feeling like they've been wronged. But I just want to clarify, when you talk about the pool, the group of Bone Spring owners that have been harmed that are on Coterra's side, it's only Magnum Hunter. Can I write that as a finding?
Based on their testimony, if you would like to say that, then that's what their testimony and exhibit says. So if you're going to base that on that, then yes.
Okay, and your counsel will have a chance at closing to clean things up if I'm
Sure.
saying these wrong.
No,
I'm
you're
just
fine.
trying to get my fingers ready. The next line says entities with greater interest in the wolf camp. Do you see that one?
Yes.
I interpret that to mean these are people that will be harmed by Coterra's plan. Am I right? Am I wrong if I type that up?
I think harmed implies wrongdoing. So Coterra's position is where's the production actually coming from? And that's important in the matter. So it's Coterra's stance that the production is predominantly coming from the Third Bone Springs. So when you say harmed, you're making an assumption that they were owed the production that Coterra states is not theirs to begin with, or a percentage of it's not based on where the production's coming from.
Okay.
So that would be my only qualification.
Yeah. Okay, that makes sense to me. So I just was trying to narrow the universe so we could be as precise as possible when it comes to closing statements and the findings. Who actually, naming names, has been harmed? And the reason is, and this isn't a question, I'm just going to tell you the context, is that there's a statutory allocation formula, and Coterra is asking OCC to use discretion and move away from that. And they're saying there's lots of grounds for it. So I'm trying to figure out what the lots of grounds are for that. That's all I have. Thank you.
Redirect?
Yes, I have just a few questions. Mr. Rankin asked you about the Harkey wells, and has from the get-go was Coterra alleged that the totality of the development plan, 48 wells, constitutes economic waste,
We do.
and the Harkeys are part of that.
That's correct.
Now, the order that you referred to on Exhibit R7, that's not the only basis upon which you're premising the 70-30 split, correct? Are there other reasons why you're not just relying on that order saying it's predominantly?
No, we're not only relying on that order. Coterra's geologist has outlined the reasons why the production should be allocated predominantly. That order is just in agreement with our findings.
And as far as people being harmed, as far as the economic side goes, step away from the allocation, but the economics, is it your testimony that Coterra's plan will benefit all the working interest owners vis-a-vis Permian Resources?
It is. We showed a rebuttal exhibit that showed the full project economics with timing and PR's costs and Coterra's costs. And we not only showed that our plan would lead to more BFIT, PVI 10 or more money, but we also showed how that we were being more efficient with the money they spend. So Permian Resources would also benefit from Coterra's plan.
And were you here for Ms. St. Pierre's testimony?
I was.
And you recall her testifying that Coterra's development plan included those we went from 24 to 30 wells. Do you recall that?
Yeah, I believe she stated that was in our full development plan.
Okay. You give me one. That's all the questions I have on redirect.
Thank you. If nobody else has any questions for this witness. Thank you for your time.
Absolutely.
At this time, I would like to move to evidence rebuttal exhibits R1 through R7.
I'm not hearing any objections.
I'll just make one comment, and it's not a full objection, but I'm just going to make a comment. I believe I would urge that this comment goes to weighing of the exhibits. Exhibit R1 goes and R2 are the type of evidence that were required to be presented as part of the direct case, because they go to the allegation or claim assertion that the fee height, it correlates to oil production, and that should have been on direct. And it wasn't a proper rebuttal exhibit. Same thing with R5. As we just heard, Coterra has been alleging that the entirety of Permian's development is economic waste, particularly the Harkey, and yet they waited till rebuttal.
I'm going to step in.
The evidence.
So
Yeah.
you can make an objection, but you can't testify.
Okay. Well, that was the basis of my objection. I was just explaining why. I mean, I'm not going to go so far as to seek to strike them, but I just wanted to make the point and urge that the commission maybe consider it as to the weight of the evidence. But with that, I'll stop.
And since he sort of opened the door, I would say the R1, R2 are directly in response to exhibits that were filed by Permian Resources, and that the same goes for the other exhibit, which I believe he said was R5, the Harkey.
Well, thank you both. But since there's no objection, it sounds like it's admitted. So it will be, but all comments on both sides have been noted. So appreciate it. Do you have further witnesses to present?
No further witnesses.
Okay. In that case, is there anything further to be presented by anybody else? Seeing no further presentations, I believe I'm now ready, unless Commission Counsel advises otherwise, but I believe we're now ready to close the evidentiary record and proceed to closing arguments. Any objections to that?
No.
All right. In that case, we'll proceed to closing arguments, starting with the applicant.
Mr. Chair, our closing attorney, Mr. Anderson, is having connection issues. I've been designated to give the close.
I think I'm back on. Sorry. I think I'm back on.
Oh, thank you.
Yeah, sorry. I was sending that to you just in case I got knocked off in the middle of my closing, but I think I can proceed.
Can you?
If everybody can hear me.
Actually, noting that, I'm sorry, I just noted the time. Do the parties wish to take the afternoon break now before closing arguments?
Yes.
I hate to, sorry.
Yeah, well, I tell you what, since he's on and he's having trouble, let's
just run through. Okay. In that case, please proceed, Mr. Anderson.
And Mr. Chair, if you can indulge me, how much time, I think we need to consult on how much time we have left. So he knows, you know. Mr. Chair, after consulting with the two parties have agreed that Coterra has 34 minutes left.
Works for me.
Professor Anderson, you have 34 minutes.
Okay, thank you very much. May I proceed then?
Please.
Yeah, my name is Owen Anderson. I'm speaking from my residence in Georgetown, Texas. I've been a professor of oil and gas law since 1979. I served as general counsel to the North Dakota Industrial Commission Oil and Gas Division for 6 years. I'm a member of the North Dakota Texas Bar, North Dakota and Texas bars, but to save bar dues, I retired from Oklahoma at the end of 2023. I've been a member of the Interstate Oil and Gas Conservation Commission's legal committee for over 45 years, and I chaired and served as the chief drafter of the IOGCC's 2004 Model Conservation Act. I have been admitted pro hoc vice to help represent Coterra in this case. I will first address economic waste. Under the New Mexico Oil and Gas Act, when evaluating competing applications, the division and commission are charged with a duty to prevent waste. Section 70-2-3 of the Act broadly defines waste as including, among other things, its, quote, ordinary meaning, unquote. The ordinary meaning of waste includes wasting money, i.e. economic waste. In the oil and gas regulatory context, the prevention of economic waste includes the duty to eliminate unnecessary expenses, including the drilling of unnecessary wells. The duty to prevent economic waste is built into the proration and pooling statute. New Mexico Statute 70-2-17, subsection C, explicitly states that the division's authority to pool lands must be exercised so as to avoid the drilling of unnecessary wells. While the drilling of unnecessary wells often prevents underground waste, it also prevents economic waste. Indeed, this same subsection C explicitly states that all orders affecting pooling shall be just and reasonable, and the owner or owners of each tract or interest in the unit the opportunity to recover or receive without unnecessary expense is just an equitable share of oil and gas or both. An article written in 1963 by Richard S. Morris, published in the University of New Mexico Natural Resources Journal, entitled Compulsory Pooling of Oil and Gas Interests in New Mexico, concludes that his examination of New Mexico conservation cases revealed that waste meant, and I'm quoting here, quote, meant economic waste rather than physical waste of oil and gas. The protection of correlative rights and the prevention of economic waste caused by the drilling of unnecessary wells were the chief considerations in ordering pooling. He then goes on, and I'm at page 319 of volume 3, Natural Resources Journal. He then goes on and talks about that occasionally physical waste was also relevant. The Morris paper is cited with approval of a Kramer and Martin in their authoritative treatise on the law of pooling and unitization in section 10.02 sub 4, noting that economic waste has been considered in pooling cases in New Mexico going back almost 70 years. Adoption of Permian's argument that economic waste is irrelevant would not only be at odds with the plain language of the statute, it would establish a precedent and policy that would thwart the primary purpose of the division's and commission's duty, which is to prevent waste. Economic waste can and should be considered here, especially at present when the short-term oil and gas pricing outlook looks so grim. Coterra's evidence establishes that Permian's plan to drill unnecessary additional wells at significantly more cost will produce only negligible additional reserves and thus constitute economic waste. If Coterra turns out to be wrong, infill drilling can always be permitted in the future if additional wells are proven to be necessary, but once an unnecessary well is drilled, the resulting economic waste cannot be undone. Next, I will address protection of correlative rights. Protection of correlative rights is a mandatory duty of the division and commission. While the duty to prevent waste is primary, the division's and commission's authority to prevent waste must still be exercised so that correlative rights are protected. Fortunately, in the present case, the commission can easily do both. Here, a horizontal depth severance bisects a common source of supply. Because of this severance, the division has maintained distance spacing proration units drawn along the severance boundary. Thus, an allocation formula is needed to protect correlative rights because the hydrocarbon contributions of each severed zone are very unequal. The Oil and Gas Act grants broad authority to allocate production. Again, Section 70-2-17C provides that all orders affecting pooling shall be just and reasonable and will afford to the owner or owners of each tract or interest in the unit the opportunity to recover or receive without unnecessary expense his just and equitable share, unquote. No language in the Oil and Gas Act dictates how production must be specifically allocated. No explicit language prohibits the use of an allocation formula in addition to a surface acreage allocation. In this case, a surface acreage allocation alone makes no sense when the correlative rights problem arises from a horizontal depth severance that cuts through the common source of supply. As discussed in the pre-hearing statement, there is ample division precedent and case law supporting the use of an allocation formula to allocate production when it is necessary and practicable to do so. Given the factual circumstances in this case, an allocation formula along the lines of what Coterra proposes is the only one that is just and reasonable to all owners of the wolf-bone pool. It is ordinarily true that absent substantial and credible evidence to the contrary, a surface acreage allocation is adequate when vertical severances are encountered. That is when small tracts are included within a spacing proration unit. This is true for most vertical and horizontal wells, and it's true even in the case of a horizontal depth severance that does not cut through a common source of supply. But here, a horizontal depth severance does cut through a common source of supply, and so a pure surface acreage allocation is grossly unjust and unreasonable. With a surface acreage only allocation and a single spacing unit, which we don't have here, the shallow portion and the deeper portion would share equally in production, even though the horizontal boundary line might not divide the common pool equally or otherwise result in either the shallow or deeper depth being shortchanged by an allocation, by a surface acreage allocation. Artificially separating the common source of supply by creating separate spacing and proration units using the horizontal depth severance boundary, as the division chose to do here, is even worse, because absent an allocation between the units, individual well production would be solely allocated to either the shallow owners or the deep owners based on the location of the wellbore. So something further must be done to allocate production equitably, justly, reasonably, and fairly. Permian proposes to award all production to either the shallow or deep owners solely on the basis of the wellbore location. They would then, of course, allocate it on a surface acreage basis to take into account the small tracts. By analogy, consider a vertical severance cutting downward through a common source of supply with a spacing proration unit, within a spacing and proration unit. To be more specific, imagine a vertical severance that divides a spacing proration unit into two tracts, consisting of the north quarter of the unit and the south 3/4 of the unit. What would the division and commission do? Well, absent voluntary pooling, they would force pool the two tracts and allocate production on a surface acreage basis, because without more information, a surface acreage allocation would be equitable, just, reasonable, and fair. Thus, the north portion of the unit would get 1/4 of the production, and the south portion of the unit would get 3/4. A horizontal depth severance is conceptually no different, except that a horizontal severance cutting through a common pool cannot be equitably, justly, reasonably, or fairly allocated on a purely surface acreage basis. Permian argues that Coterra's allocation is unfair. What is Permian's solution? To divide the production on a surface acreage basis and by wellbore location, without regard to hydrocarbon drainage from the common source of supply from both above and below the depth severance line. This brings me to Permian's misconstruction of the Oil and Gas Act. Permian's position is that the surface acreage allocation is mandatory because of its misconstruction of the law. Regulatory spacing and pooling laws were enacted to address waste that rose due to what I call the small tract problem. Because pooling led to combining small tracts, production from a unit well had to be allocated to protect correlative rights. Through its pre-hearing statement, Permian states over and over that the compulsory pooling statute mandates a pure surface acreage allocation, rather than an allocation that better protects correlative rights. Permian's argument relies on its flawed interpretation of a single sentence in the compulsory pooling statute that mentions surface acreage allocations. That's in subsection C of 70-2-17. In relying on this single sentence, Permian fails to read the Oil and Gas Act as a whole and fails to read the proration pooling statute as a whole. When reading and construing a statute, no part of a statute can be ignored. All words and phrases in a statute are to have meaning and should be given equal weight with other provisions. Instead, Permian singles out one sentence and then misreads it. If that single sentence addressing surface acreage is all that matters, then the other portions of the statute, indeed many sentences, would be neutered. And there would be little for the division or commission to do in issuing a pooling order, because a title attorney could determine land descriptions and then allocate production based on surface acres, and then merely file a title opinion with the division and commission, which could then be summarily approved. Well, let's consider this sentence on which Permian relies. It provides for, quote, for purposes of determining the portions of production owned by the persons owning interest in the pooled oil or gas or both, such production shall be allocated to the respective tracts within the unit in the proportion that the number of surface acres included within each tract bears to the number of surface acres included in the entire unit, unquote. This provision does nothing more than require production within a unit to be allocated on a tract basis, where a spacing proration unit consists of multiple tracts. Tracts, both surface interests and mineral interests, are always expressed in terms of acreage in land patents, land surveys, and when forming spacing, proration, and pooled units. Surface acreage is used by title examiners when doing drilling and division order title opinions, when assembling unit acreage, and surface acreage is customarily sufficient for allocating production in a garden variety pooling situation. But here, Permian conveniently ignores the fact that this is not a garden variety pooling situation due to the horizontal depth severance that cuts through a common source of supply, and the division's creation of a separate spacing and proration units along the boundary lines of that horizontal severance. Permian ignores both of those facts. Again, pure surface acreage allocation typically works well without further allocation. For example, where a spacing proration unit is 320 acres and is comprised of 4 equally sized tracts, then each tract would be allocated 80/320, or 1/4 of the production from the unit. In this common example, a simple surface acreage allocation can be, and generally is, equitable, just, reasonable, and fair, and it does not offend other provisions of the statute. A surface acreage allocation also works if there is a horizontal depth severance that does not cut through the common source of supply, because the severance would have no effect on ownership within the common source of supply. However, where a horizontal depth severance cuts through a common source of supply, application of a pure surface acreage formula for pooling small tracts within a spacing unit requires an additional step to account for the portion of recoverable reserves that lie above and below the severance boundary. Indeed, allocating production to account for recoverable reserves above and below the severance boundary is the only way to equitably, justly, reasonably, and fairly allocate production in the pool. So to build on this example, assume that a horizontal depth severance cuts through the 320-acre unit within the common source supply. Assume that horizontal difference boundary cuts through the common source of supply, leaving 90% of the recoverable reserves above the boundary line and 10% of the recoverable reserves below that horizontal boundary line. This is easily resolved by further allocating production by reserves above and below the horizontal boundary line. Allocating 90% of production to the owners holding the shallow rights and 10% holding the deep rights, and then further allocating production to each 80-acre tract. This is what Coterra is proposing to do. It is simple, equitable, just, reasonable, and fair, and moreover, it is practicable. In contrast, a surface acreage allocation would give the deep owners 50% of the production and the shallow owners 50% of the production, which would be grossly inequitable, unjust, and unfair. Yet Permian's proposal would further exacerbate this situation and this unfairness by artificially subdividing the common source of supply, by allocating all production solely based on where the wellbore is located, and then further allocating production of surface on a surface acreage basis. In my example, a well drilled into the deep formation would get 100% of the production, even though it holds only 10% of the recoverable reserves. And the uncompensated drainage would result to the detriment of the shallow owners whose zone holds 90% of the reserves. Note again, this artificial subdivision would never be allowed if this boundary line was a vertical one. Permian has argued that the surface acreage allocation sentence prohibits allocations because any other allocation would deny either the Bone Spring or Wolf Camp owners 100% of their prorated surface acreage share. That much is true, but completely inapposite in this case. If the surface acreage sentence in 17C is read to prohibit an allocation formula beyond surface acreage, then the sentence nullifies other provisions of 7217, namely subsection A, which states, quote, so far as is practicable to do so, afford to the owner of each property in a pool the opportunity to produce his just and equitable share of oil and gas, etc. This, if you read the whole provision, it's a statement about geology, not geography. The surface acreage sentence would also nullify the first sentence of the second paragraph of subsection C, which requires that orders affecting pooling result in a just, reasonable, and fair allocation of production. Just because surface acreage allocations are the most common does not mean they are exclusive, where substantial and credible evidence indicates that something further should and can be done. Even Permian admits this when it says such allocations are rare in its pre-hearing statement at page 21. When you combine all of the terms of 17